My name is Steve Sansons. I'm running for State Assembly District number 13.
Hi, my name is Michael L. McDonald, and I'm running for Assembly District 20.
I'm a former Marine. Actually, I'm still a Marine.
I have a lot of experience in a vast amount of industries.
We need to apply the 7th Amendment in our family court system, a right to a jury trial.
I did Boy State when I was in high school and learned about the process up in Carson City.
7 members of a jury decide whether to destroy a life or save a life, and we need to do that quickly.
I plan on setting equal parenting, or putting bills in place for setting equal parenting. The DV laws, the bail amounts, there's so many things that need to be addressed.
We're back on the record. Thank you, Counsel, Mr. McDonald, for giving me a moment to review some documents. Thank you, Mr. McDonald, for giving me a moment to review some documents. Come on up back to the witness stand. I'm going to ask you to put your phone away. Counsel, continue.
Where are you currently living?
Close to UNLV.
Can you tell me your address?
I'd prefer not to, as I don't want to be stalked.
You don't want to be stalked?
Judge, I've been being stalked recently as per my evidence, and I would not like to disclose my address.
Okay.
But you're not currently living at 5812 Harmony Avenue?
Correct.
But that's the address you have listed on your most recent financial disclosure, correct?
I sometimes use it as a mailing address.
And whose address is that?
Stepdad.
Are you currently working?
I do odd jobs currently.
Incorrect. Michael works in IT. He doesn't like paying child support, so he underreports his income.
What type of odd jobs do you do?
Depends. Some computer stuff, some real estate stuff, cleaning up things like.
Okay, and how much do you get paid for those odd jobs?
I try to make it. I do as much as I can to make $800 to pay my bills, like at least $800 a month.
Michael reports that he makes just enough to take care of himself, but not enough to give any away.
Okay, and you realize that you've listed on your financial disclosure that you make $0, correct?
I don't believe that's true.
Do you have a copy of your financial disclosures that you filed?
I don't think I do. I think it's in the exhibit list. It might be over there. So I'm also a student right now and doing my best to get work, as I tried to get rehired at my old job and was unable to.
Odd jobs, computer IT, real estate, and currently a student. Sure sounds like $0 to me.
As they have DOD contracts and they can't have people with domestic violence.
What are you paying for school?
I'm going for financial aid and scholarships.
Exactly what scholarships are given out to felons in their 40s?
You're submitting paperwork for that, or you already have that?
I submitted for financial aid, yes.
But you're not currently receiving it?
I got approved. I didn't get approved for last semester, but I should be getting approved for this upcoming semester.
Fucking madness.
So you went to school last semester?
Yeah.
How did you pay for school last semester?
It was through financial aid. I think I still owe them some money on that, so we're still waiting on the funds for that.
Okay. when did you start it? And you're attending school at UNLV, is that correct?
Yeah.
When did you start attending school there?
The semester after I got out of jail.
Sweet baby Jesus, pray for this maniac.
It's the winter semester of 2017.
Isn't that semester still going?
No, it's spring semester.
And on your financial disclosure, despite listing that you make $0, you claim $800 in business expenses, correct?
Counsel is now talking about Michael's financial disclosure form. A financial statement is a court form in which you set out all your financial information, including your income, expenses, assets, and debts.
Maybe I filled it out inappropriately. That 800 is around what I'm currently going for each month. I'm doing my best to earn.
Michael's doing his best.
Okay, because you also, so you have on your business expenses, you have a car and truck being used for business that you spend $100 a month on.
That's a gas charge, I think.
For insurance, $100. For mortgage or rent, $550. Are you renting out an office space?
A what?
It's zoned commercial and residential.
So you're living there?
Possibly, yeah.
Michael is maybe going to live in a property that is zoned for both commercial and residential. Dr. Business thinks he should think about living in a van down by the river.
And utilities of $50, correct?
That's part of the 550. Yeah.
And so you have. So you list here that your average gross income from self-employment or business is $800, correct?
It fluctuates, yes.
And then $750 in business expenses. Okay. And then you also filled out the personal expense schedule, and you have a total monthly expenses of $1,050.
Yeah, so I also have a rental contract where I can have reduced rent for doing different jobs around, and it's my friend's house, so.
Okay, so is that a business address or is that a lease? So you're paying $550 for rent on a business and $500 for rent on an apartment?
It's a commercial and residential place.
It's a fucking garage. That's what he's talking about. A fucking garage.
Decent. It's a big place that I have. I also have beds for my kids. I have everything in place for them as well.
Okay, but if you're, as you say here, if you're making $0 a month.
I didn't state that.
I'm going to have you. You don't have a copy of your financial disclosure.
No.
I'll have you look at this. Can you just review that real quick, and then I'll ask you some questions?
Okay.
Does that appear to be your financial disclosure?
Appears to be.
Is that your signature on the back page?
I believe so.
Is that your handwriting with your name at the top of the front page?
I believe so.
Okay, and if you look on the second page, what does it state for your annual income? Up towards the top.
Year-to-date income, is that what it is?
Yep.
Yeah, I don't think I filled that out. It wasn't.
Does it have zeros written?
Oh, I think it's question mark because I don't know exactly how much it was.
So those aren't zeros.
I was unemployed for over.
Category?
Oh, this year 2018. Yeah. Yeah, I wasn't sure what to put there.
The record speaks for itself, counsel. I can see the financial disclosure form that he filed with the court that says gross monthly income 0.
Michael has now been caught lying on his financial disclosure form.
Okay, so I might have weight divided by 12.
0, 0, 0,
Yeah,
0 divided by 12,
I didn't
0.
know how to put
Judicial burn.
that.
Okay. Next question.
Isn't it true that you took a trip to Washington, D.C. recently?
Not recently.
Within the last year?
The year of 2018 or 17?
2017?
Yes, it's true.
After you got out of jail?
Yes.
When did you get released from jail?
I believe it was June 6th of 2017.
Okay, were you working at that time?
I was in jail.
So how did you afford your trip to Washington, D.C.?
How did I afford the trip?
Yeah. How?
I had a sponsor. My dad helped pay for some of it. I actually visited him as well. Afterwards, I haven't seen him in years and was able to spend quality time with my own
Does
father.
your dad live in Washington, D.C.?
No, he lives in Florida.
Okay, so you traveled to Florida as well? Okay. Have you taken any trips to California since you got out of jail?
Not that I recall. There might have been one. I had to go to Bakersfield to drop something off, but that's the only thing I can think of.
Have you made any trips to Carson City since you've been out of jail?
Not that I recall.
It is critical that we send a strong and principled citizen legislator like Michael to Carson City.
Okay, of all the trips that you have taken, how have you afforded to pay for those trips?
Michael's whole bullshit defense now begins to crumble.
There was let me think. Like I said, I had some sponsorship on some things. Some people helped. Like my father, for example, paid for a lot of.
What were you being sponsored for?
Sponsored to, like I said, my dad helped pay for some of these trips.
So he
And
gifted you money?
My grandma recently passed away, and he's helping take care of her. And how she passed away, which my grandma, my own kids never got to see.
Fuck off.
And she passed, and the house was cleared out, and I actually went to Florida and saw him and spent time with him, and then we came back to Vegas. He actually moved back to Vegas recently. So.
Okay. Since you got out of jail, have you attempted to find gainful employment?
Michael has a steady, salaried job in IT.
I have actually, yeah. I did apply for a couple of jobs as I'm going to school, so I'm
Have
trying
you
to.
submitted applications?
I did.
Did you provide any of those applications for court today?
I didn't know I had to, but I did get it denied because of the criminal charges. So.
Motions at Candace with his left hand as to blame her for bringing said criminal charges against him.
But I'm doing my best to
Fuck your best.
get into real estate, and that was help sponsored, and I plan on being a great realtor one day, and along with studying the law. So.
Do you have a real estate license right now?
I actually just took the test, and I got 72 out of 75, so I'm retaking it very soon, so I should be one pretty soon.
Have you provided any proof that you have taken the test for your real estate license?
No, I had to.
I have no further questions, Your Honor.
Anything? Do you have any other witnesses?
No further witnesses.
All right. Mr. McDonald, is there anything else you need to tell me in a testimony kind of way before we get to closing arguments?
Dr. Business says brace yourself. For real, it's on.
I would just like to say that continuation of there's a lot of things that were never rebutted, or a lot of evidence, or lies and complete libel and slander that have been perpetrated by the council, that I never had a chance to. I didn't have effective representation that presented that.
Okay.
And I would like the court to take that into weight. And this should be a matter of joint physical custody, which there should be there should not be denied access. Now I understand the judge's concerns about different things, and especially when lies that were rebutted, I didn't understand the rules of the court. I didn't understand that you had to refute those things or file pleadings. I had to almost become an attorney, and I don't agree with that in this system. I really believe that we should have proper representation. There's so much to law. I study in the law library a lot, and I don't think I'll ever be able to know all the laws in there. There's books upon books and codes that will never. No one man can know all the law. And it's the
Okay,
interpretation.
anything else you want to tell me about custody?
In regards to custody, the judge, I would.
Or you want to...
I like to save it for my, I guess.
Oh, okay. You take all your stuff back over there. We're going to have closing arguments now. Mr. McDonald, you're going to go first. I'm going to give you 15 minutes or less. And then counsel's going to go. I'm going to make my decision today. I'm going to issue my decision. Then a written decision will more specifically describe each and every element and each and every fact I've found. But I'll give you a specific decision today. And then we have some other dates we need to set. So go ahead, Mr. McDonald.
Well, Judge, I understand that today's hearing is based on custody, and since it's been over 450 days, Judge, since I've last seen my children. There's no warrant for that, Judge. I wish there was a way and that's why I tried to file a bunch of different things. I didn't know what to do in this court. I just wanted to be able to show, look, this isn't what happened. I've made a lot of mistakes in the past 3 years. A lot of emotions are there, and so many things that I had no clue. I learned so much, Judge. I learned about our legal system. I learned I've never been involved in the legal system before, even though I've got some family that are. But I just ask that the judge look through the lies and and understand the benefits of being a father and the psychological issues, and I've presented in my case study and in my CAP study and other means and expert reports. I want my children to have healthy, good, loving relationships between both parents. It's in their best interest to have a mother and a father, and I feel as though my parental rights have been completely stripped of me on warrantless hearsay and different things that no standard of evidence as well, Judge. Just things saying that this is so, and no proof, not beyond a reasonable doubt. I'm still kept. That's why I asked for a hearing, and as soon as I got out of jail, I wanted to see my children. And yeah, there's a lot of recovery, and I did a lot of that in jail as well, but I've never experienced that. It was an eye-opening experience, Judge. I was able to help minister a lot of guys in there, and then there's so many people suffering and being thrown in jail for frivolous reasons, in my opinion. And I believe that our prison system should be a way of reforming people and making them
We
better.
can spend your 15 minutes talking about the prison system and reform.
Let's talk about just...
All right, but let's talk about, I'm going to keep you focused. I'm going to help you out here. Let's talk about your children and your request to modify.
Okay, first of all...
You don't say, first of all, at the end.
I want to bring up NRS 125.
No more NRS bullshit.
NRS 125C.0035, as this is on my pretrial memorandum, that first of all, we need, in determining, after an evidentiary hearing held pursuant to subsection 5, and this is NRS 125C.0035 and section 6, so if after an evidentiary hearing held pursuant to Section 5, the court determines that each party has engaged in acts of domestic violence, it shall be possible that determine which person was the primary aggressor, in which determination the party was primarily the physical aggressor for purposes of this section. The court shall consider all acts of domestic violence involving either party, the relative severity. So there was no acts of domestic violence previous to that hearing, Judge. That there was nothing on record. There was no acts that was perceived that were
Talking about before August 2016
before
or after?
Before, Judge, yes, and
Okay, so
afterwards.
remember that I'm focused on
So since
what happened after August.
since the last order of this court, there was a presumption or a conviction of the domestic violence. That
Trash. That's what Michael is. Trash.
conviction is on appeal, and there was denied due process of law. there was a max sentence, Judge. There was a lot of things that happened in that.
What was the due process violation?
One that I was denied equal access to protection of law. I was denied my right to an attorney when I asked for a paid one.
Michael is very upset that legal aid didn't Johnny Cochran his problems away.
I was also asked.
You had a public defender, though, correct?
Yes, but
you wanted a paid attorney. What is a paid attorney?
I wanted to hire private counsel.
Did you hire private counsel?
I was unable to.
Why were you unable to?
First, my financial situation. After
you didn't have the money.
Well, I wasn't able even allowed to look.
Who did you want to pay for it then?
Somehow I would have come up with something that I didn't understand the severity of those cases. And if you
Michael didn't understand the severity of these charges: failure to obey a protection order, domestic violence; battery, domestic violence.
If you look in the pretrial memorandum, the appellate briefs,
you outline it there. Okay, thank you.
So answering all this, all prior acts of domestic violence, the defendant has no prior history of domestic violence. The severity of the injuries, if any, inflicted upon the persons involved in those prior acts of violence. The allegations, and it was false, that the defendant pushed plaintiff, and that he didn't slam her, broke her nose, or slammed her against the floor. There was no marks. There's no blood.
How goddamn dare you?
But pushed her. The severity is clearly a factor this court should consider. And if you look at the appellate briefs, Mr. Niddick did a good job in describing what that situation. Subsection C, the likelihood of future injury. There is no likelihood if orders are made for public or not in-person exchanges as the defender desires. There's no likelihood of injuries. If we did the exchanges, we're good co-parents. There's no reason for that. I have a suspended sentence. There's no. I'll do my best to follow any order.
Trash, 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 trash.
I'll do my best to follow any orders of this court. Whether during prior acts that one party acted in self-defense, there's even allegations she pushed me at the daycare and different things of punching that was never addressed or never presented. And I had evidence that could have helped with that, but. E, the factors which the court determines relevant to the determination. Defendant's history as a good and loving father is relevant. I had my kids every weekend. I used to take care of them. I'd watch them when she would go to night school. The kids, it's in the best interest of the children to see their children. It's in the best interest of the children to see their children. And the harm done by plaintiff's abuse of process and setting defendant up should be as relevant. So that is one thing. Another section is NRS 125C.0035 deals with the best interests of the children. In any action determining the physical custody of a minor, the sole consideration court is the best interest of the child. The further states the factors considering the determination of best interest of the child. A, the wishes of the children. If the children are sufficient age and capacity, intelligence, preference to his or her physical custody. I would ask this court to allow Mason to come in here.
What did you just say?
I would ask this court to allow Mason to come in here. He's 6 years old. He's way beyond a normal child. It doesn't state exactly age. I think if he was in here, if he wasn't completely poisoned, or if he was able to speak, he would say how he loves his father, wants to be with him.
That may be the worst thing Michael has ever said. What he just said upsets me.
I would ask this court to allow Mason to come in here. He's 6 years old. He's way beyond a normal child. It doesn't state exactly age. I think if he was in here, if he wasn't completely poisoned, or if he was able to speak, he would say how he loves his father, wants to be with him. B, the nomination of guardian for the child by parent. Defendant nominates himself as he would not cut the other parent out of the children's life. I've always encouraged a relationship between the mother and as I showed her, we both agreed to Christmas visitations, other things that it never allowed defendant, even his birthday. He asked for his birthday, he asked for Father's Day, would always be denied.
Fuck off, denied.
And under our statutes, that should be one of the highest expectations in order. So this is the order that should be determined by this court. C, the parent is more likely to allow the child to have frequent associations and continue relationship with the non-custodial parent. Clearly, this is the defendant. It cannot be denied that the plaintiff has abused process and used the TPOs to bait the defendant and set him up for the violations. So, she has not fostered any any frequent associations. She's in fact tried her best to alienate it. You could see her testimony is, you shouldn't see the kids, and saying how bad a parent.
We all know that's not what Candace says. Candace wants Michael to get help so he can get better.
That has not been said. I could have a lot of witnesses
Mr.
coming.
McDonald, you know she didn't say that, right?
She said she insinuated it, Judge.
She didn't say you were a bad parent. Do you remember what she said?
I don't even think she wants this to happen, Judge.
No, I think she does. I want you to hear what she said again. The kids need you, but they need you to be healthy and make good decisions.
And I think that I've proven that, Judge, all the things that I've done.
I want to make sure you heard that again. Her position was, the kids need you. She wants you to be a father. She wants you to be in their lives. The kids love you. But no. I want you to listen. They need you to be healthy. Did you hear that?
Yes, Judge.
Okay. That was her position.
Everything rests on Michael's decisions. It is possible for him to get the help he needs and turn this whole thing around. But it's on him to do it.
And that's why I tried to clarify what is healthy, what do I have to do, what mountain do I need to climb, dragon I need to slay, what do I need to see my children? You know, that's why I asked her, and she can't give me that's why I asked this court, like, what do I have to do? I just want to see my children. That's all. Like, I want to be in their lives. I want to be a good father. I want to go to the events. I want to go to their birthdays. I want them to know my family as well. So that's all. That's what I want. And this is the ability of parents to cooperate. Sadly, the plaintiff is bent on winning. She has lost sight of what is best for the children and would not co-parent. The court will require the plaintiff to attend co-parenting classes. This would benefit the children. The mental and physical health of the parents. There's no significant mental or physical health issues of the defendant. Defendant cannot speak to the plaintiff's mental or physical health. However, it's evident that she suffers from pathogenic parenting. The exhibits show her giving defendant her gate code and having him go to her Starbucks and tells the court that she is afraid of him. During the marriage, defendant was never alleged to have convicted domestic violence, never charged with domestic violence, never had police at the residence. If truth be told, plaintiff was physical to defendant, and the marriage dissolved after the plaintiff resumed an affair with someone on Facebook and Christian mingle while married. The physical development and emotionally judged. I want to be there to foster the development of my children. I know that effect of not having a father. I know that kids need their dad. Like the people I talk to that have been suffered so much by not having yesterday we had an author come in. Her name's Samantha Jada. She was sex trafficked as she was denied her father. And she actually got some legislation passed in California, and she's been doing great things out there. The nature of the children. The nature of the relationship of the children with each parent. The parent have a good relationship with both parents, and they need until pathogenic parenting of plaintiff. The ability of the parents to maintain a relationship with any sibling. The history of the abuse. There's no history of parental abuse or neglect on part of the defendant. Whether either parent or other person seeking physical custody has engaged in acts of domestic violence against the children. Now that is K. That's on the lower standard of all these other ones. And I believe that bears weight on not allowing meaningful.
You're saying that because of the list of the best interest factors, I should give more weight to the first factor.
It says that, Judge. Yes.
Rather than the last factor.
That's written in our NRS statutes, yes, Judge.
Right.
And there has been no abuse. There has been abuse of process by the plaintiff. The allegation is defendant pushed the plaintiff. Pursuant to NRS 48.125, defendant pleads no contest should not be considered in the action where the parents or any other person seeking physical custody have committed any act of abduction. Since defendant's primary objective is to remove or minimize the plaintiff and his children, there's nothing less than attempted act of abduction. I've never abducted my children, Judge.
The daycare. I don't need to say more.
They have claimed I tried to abduct my children. Never have I done that. That's complete hearsay and lies. I wouldn't do that. I know there's a felony charge. Why would I? And also, why did I go?
What were you doing at the daycare that day when you picked her up off the mat?
Judge, I believe that was my day for custody, as I had every other weekend that was ordered by this court. So I went to go pick up
No,
my
you
daughter.
were ordered the 2nd and the 4th, the weekend defined by the first Friday of the month.
Yes, Judge.
So you thought that was your second
I believe
weekend.
it was the second Friday, yes.
And so is that how you normally go in and pick up the kids? You just
Judge.
go in and sweep them off the mat and walk out? Or do you go in and you sign them out and you get their backpack and you walk out?
That day I went early because there was a doctor's appointment that was scheduled. So
Michael makes bad faith doctor's appointments.
usually I go after I get off work, which was around 4 or 5 o'clock. So that day I went there around 2:30, I believe, and then she must have just been getting off work and ran up and started shoving me, and it was an altercation there.
No, I'm more concerned about you taking the kid off the mat and it being the wrong kid, and then you getting the
Judge,
Malia, and then you walking out. You know, that looks really bad, Mr. McDonald. What I need an explanation. I never got that from you today through all of the time that I gave you.
Yeah.
Why was that going on?
Judge,
Why are you?
I didn't try to take somebody else's children. There was dark in the room. There was
Well, it was nap time.
Yeah, so it was nap time. I go in there and looking for my child, and I saw a person there. I didn't grab their child. I said, "Oh, that's not her." I didn't pick that child up.
Did you touch her?
And I asked, "Hey, where's Malia?"
Did you touch her?
No, I looked. They were covered up over the head. I saw blonde hair. I thought it was my daughter. So
Okay.
I did not pick up that child. I don't even think the child woke up, if I recall right. And then I asked, "Where's Malia?" She pointed over there. I grabbed my daughter, and she woke her up. She was okay, a little groggy, and then I walked out. As soon as I walked out the door, Candace runs up and, "You're not taking her." He started cussing and stuff and started shoving me, Judge.
If Joe was with Candace on that fateful day at the daycare, Michael's day would have gone differently.
So and she has these bouts of rage or whatever and anger that it was through the marriage. I never laid hands on her, Judge. I wouldn't do that to somebody. I know better than that. All right, I did some emotional things that.
You keep saying that you did emotional things. I don't really know what that means, and I don't know what. So if you
trying
wanna,
to get her, trying to get her back, and trying to do. I'm done with all that, Judge.
So that was the emotional things that you say were a mistake, was trying to get her back.
Emotional things, confusing the orders. I didn't understand how to follow. Like, Judge, there's a lot in this case that.
Okay, well, in the future, I need you to make sure that you understand every single order before you leave the store. So I'm going to ask you a bunch of questions about every single order every time, okay? And the reason is because you're telling me you're confused about a stay-away order, you're confused about the TPO, you're confused about the custody arrangement, you're confused and you didn't know if it was a criminal trial or not.
Michael knew enough to plead nolo.
Okay, so I'm worried that you're not understanding everything that's going on. So from here on out, no offense to anybody, but we're going to take a lot of time. When I make an order, I'm going to ask you a lot of questions and make sure you understand it before you hit that door. You understand?
Yes, Judge.
All right, okay, keep going.
Okay. So, let's see. Oh, there is a statute called NRS 125C.020, Rights of a Non-Custodial Parent, additional visits to compensate for wrongful deprivation of right to visit. As you can see in my exhibits, the exhibits of the Thanksgiving weekend I was supposed to have, she denied those visitations. I have those police reports on there. I have one denying Christmas, denying birthdays, emails between her counsel trying to see the children. So I would ask her for some kind of compensation time to be able to see my children. I miss out. I can never make up a year of my children's lives. Memory of the right of first refusal. If somebody wants the kids, I should be that person to watch them or given that right first, as I'm their father. Don't let a babysitter watch them, or I'll afford the same thing to her. If anything, hey, you want to watch the kids? I got this going on. And if she said no, then I would come. I'm a father. I would take the appropriate steps to find an appropriate babysitter that would watch my children. So and take an additional. So that was in a dispute concerning. Right. And there was also NRS 125C.0645, the form of an agreement. We both agreed to things, and we had one before we came to court, and then everything got degraded. I believe that we both can come up with a visitation or a custody exchange and custody thing by ourselves, if possible. We can both say, hey, this works and this works. I know that we're both adults and that we can have those disputes. If there wasn't a matter of primary or not, whatnot. Let's see. I went through those NRS 125 statutes. There is a case called Barbagallo versus Barbagallo, which is the proportion that this court should not adopt it should adopt a 40% timeshare requirement is displaced. So this was in determining the factors of the court for joint physical custody of when there's a determination, and it clarifies that arrangement constitute primary and joint physical custody, and that I would agree that if we could come up with some kind of time of 03 overnights, that would be agreeable. Sevely versus Sevely, a party seeking modification of custody provision of a divorce decree bears the burden of demonstrating that a material circumstance of facts affecting the child's welfare has occurred since the initial divorce decree, and a modification is in the best interest of the child. So Sevely versus, in regards to that, there has been lots of change of circumstances, and one of them is being denied access to their father. They should be able to see them and have a meaningful relationship with them. I could go on. Ellis versus Carucci, that is another one that's in place. There's a lot. I could keep Castle versus Simmons, Pena versus Pena, and there's Mosley versus Felizaguli. And there's one more thing that I would like to say, Judge, is that there was a landmark case that was put in place for determining custody and put in our NRS statutes. I believe that was NRS 148. I'm looking for it right now. But we have a set standard of what this court should follow in regards to determining custody matters. I know it's what is in the best interest of my children. I mean, our children. I know what. And both of us will both agree to what happens, and I think it's best for them to see their father and to have meaningful time with them, and to help the father to help bring them in the world, to be there for holidays, to be there for events, to have them to bring meaningful trips and memories, to have good co-parents to help raise them. And I think that I've proven, Judge, I've done everything this court's asked and more. There's the counseling, the thing. What else do I have to do, Judge, to prove to this court that I'm a fit, willing, and able father? And that's what I'm here today for, to show. Look.
All Michael has done is verbally beat up on Candace.
This is a extreme case of parental alienation, and it's going to cause deep issues with our kids. I hope that right now they're young. I really hope that we can remediate that before that happens. And I'm going to continue I want to continue to have meaningful relationships and build that relationship back up with my children. And I don't know how over this year is going to how I can ever make that up with my children. But I know I can show this court that I've remediated by myself or changed things, and to see the issues. And there's also in our statutes that in determining custody of a child, when that if a parent, it causes the parental or prevents time with the other party, that they be awarded compensatory time, or that a lot of case laws where it's reversed, where the custody is brought upon the defendant over the plaintiff. And I believe I've proven all that case. And if you could see the evidence that I've had, the baiting, the entrapment, has she ever been hurt? And during since your last order, Judge, I've stayed far away from her. I've done everything I can to follow this court and the municipal court's order.
Did you do your best?
And to become a better man and a person that my children can look up to one day. And I ask that you take that into weight when considering joint physical and legal custody of my children, Judge. And I thank you for that. And I'd like to. Is that my closing statement?
It is. Thank you.
We will now hear counsel's closing truths about Michael and his true behavior. Get ready for some satisfaction. Dr. Business will not be interrupting counsel out of respect.
Counsel?
Your Honor.
You can have a seat, Mr. McDonald.
I do find it a bit intriguing that defendant wants to feign ignorance when it comes to following orders, following any recommendations by the court, yet is able to come in today and cite statutes, cite case law, cite all these issues, but yet is somehow, when something doesn't go his way, is ignorant and doesn't understand what he was supposed to do. Today we're here on defendant's motion to modify. He carries the burden of establishing that there has been a substantial change in circumstances affecting the welfare of the children, and that it is in the best interest of the children to modify the current custodial arrangement. Today he has brought in no evidence that the circumstances have changed. He's readily admitted to being adjudicated guilty of 3 violations of a protective order. He's admitted to being adjudicated guilty of battery, domestic violence. He has an inability to accept any responsibility for his actions, which is probably the most concerning thing, that there's no way he can get better if he doesn't understand that he's done something wrong. And today we've sat through hours and hours of testimony of him trying to show how Candace is wrong. I've been baited. I've been entrapped. But yet he provides no proof of any of this. He claims that he's been compliant with everything the court's ordered. He's done nothing that the court's ordered. He didn't produce any of the evidence timely in this case. He didn't do any discovery. He didn't produce anything to show that there's been a change in circumstances or that it's in the best interest of the children. Adversely, we've only seen evidence. He wants to focus on Candace's boyfriend that has been definitively proven to be somebody different than what he thinks, but he cannot let that go. He was ordered to get a psych eval. He chose not to do that. He's been ordered to do domestic violence classes. He's produced no evidence other than the 15 that were done. While in jail, he's produced no evidence that he's actually done any classes to help better himself. And he continues to say that he wants to be a good father, he wants to do everything, yet his actions show completely different. And like Candace has testified today, it's not her intention to alienate their father, to kick their father out of their life. Adversely, she wants him to be. She knows, she understands that it's good for her kids to have a father, but he has to be healthy. He can't be talking about very sophisticated court things. He can't be doing YouTube videos and saying that he wants to do something to Candace. He can't be out doing things that are contrary to being a good father. It is our position that there has been no evidence presented today that would justify a modification, that we believe that if defendant is ultimately able to complete domestic violence classes, if he gets a psych eval and gets the help, he does the counseling, does what it takes to where he can be a productive father and not harm the children with his actions, that eventually supervised visits can be reinstated. At this point, there's absolutely no justification for joint physical or joint legal custody, and we would ask that, based on the evidence that's been presented today, that we maintain the status quo until defendant can show that there has been a change in circumstance and that it is in the best interest of the children for him to regain supervised visits or whatever the court would decide.
Thank you, counsel. Mr. McDonald, briefly, in reply.
Again, Judge, counsel is poisoning the well further, saying that there is no evidence that was presented. Judge, there's a stack of evidence here, 80 pages or more of evidence and things that show that are relevant to this case and changing it as a change of circumstance. There's a mountain of evidence of things that have changed in the circumstances of this case. And again, to poison the well and to come up with complete lies, just to throw them on the wall and not not rebut. And to say that I haven't complied with the court orders, I've done the classes, I've done the counseling, I've done, what else do I have to do? You know, I still plan on going attending these groups, and see, I'm bettering myself, Judge. I learned so much. I didn't know every little detail of domestic violence and this thing and control and what is it? There's so many things that I learned over this past year. I'm better for it. I mean, I'm not gonna. I will admit that I made a lot of mistakes. This is the most tumultuous time of my life. It's torturous not to see your own kids, Judge. I can't tell you. I can't even sleep at night. You dream of. You think of.
Shut the fuck up. Sit the fuck down.
Your kids. You pray for them every night, and you can't see them. You don't know how they're doing. Judge, if you have children, you understand.
Mr. McDonald.
Judge,
don't go there with me. We've been there before. Do not mention my children in this courtroom ever again. Do you understand me?
I meant a person that has children, Judge. I apologize for that. I'm sorry. What I would say is that it's devastating, Judge. It's torturous to not be able to see your children. If you ever watched the movie Miss Doubtfire? When he goes and dresses like a woman, he goes in there, becomes their nanny, and does everything he can to be in their lives, even if it has to be being their provider.
Nanny. Mrs. Doubtfire was a nanny, not a provider.
It's because people go crazy, Judge. They want to see their children. And most people are good parents. They love their children. They'll do anything for them. And to separate it because of money and because of vindictiveness, it's not best for the children, Judge. I was a great dad to my children. I would spend time with them so much. I would teach them things, never put them in front of the TV. We'd go swimming. We'd do all these things together. And my kids are awesome, amazing children, Judge. And I wish I could bring him in here and he could even attest to that, you know. And I don't even know if I'll recognize him. He was about half my size when I last saw him. He's probably like, I don't know.
The tension in this courtroom is palpable. It's all because Michael is getting desperate.
And my little girl, she was 2. She barely talking. I just taught her how to walk, and she was. I just want to be a father, Judge. I didn't have children not to be in their lives, and I take responsibility for me to be in their lives and to do that. And whatever this court finds, I'll do whatever it takes to see my children. And to be co-parents, I'll stay far away from her. I don't want anything to do with any kind of allegations. I'll make sure I record everything and have a witness or whatever it takes in that regards. And I would like this court to order set things that make sure that something like this doesn't happen or set up. And I'll make sure that would. I never thought that would happen. And I've been, Judge. It's emotionally devastating. I mean, to lose my house, my job, the means of income, like. I was planning on giving my house to my children one day, you know, like, I just can't believe it. And now trying to buy a house in this market, it's crazy. So, Judge, I ask that it is in the best interest of the child. I have had a burden of proof to show this court that it is in the best interest of the children to have their father in their lives, to have a joint legal and physical custody. And I've showed this court that there was evidence of the parental alienation and pathogenic parenting, and I ask this court to take weight to that as per our statutes, and that goes through to each one, and that you are able to give the domestic violence weight what it is, as it states in our statute. Is if there was evidence of it, there was a severity of that. I'm not a woman beater, Judge, and what counsel would probably try to negate. I love my children. I just want to be in their life, and not being able to see them in a year, it's been devastating. I've overcome by God's grace. He's helped me so much in this, Judge, and and this is what things that's keeping me going. To my relationship with God, and I thank Candace for that too. We used to go to ministry together. We used to go to these things and she helped bring me closer to Him, and He's been helping me through this difficult time. And I hope that you can see that Judge, and know that I'm a good, fit, willing, and able father for my children, and that I have shown you the change in circumstances and that I am a remediated man, and that I won't do it, that I will follow this court's order, and I'll do my best to be a good co-parent and good father for my children. Thank you.
Absolutely pathetic. This has been the most ridiculous day. And it's not over yet. We have reached the crescendo.
Mr. McDonald, your motion to modify custody is denied. There has been a change in circumstances. You've been convicted of 3 TPO violations and 1 domestic violence. You have done absolutely nothing. There is no mountain of evidence to rebut the presumption. She will continue to have sole legal custody and primary physical custody. All visitation, including supervised visitation, remains suspended. I will issue a written order forthwith with findings of fact, conclusions of law.
The righteous wrath of the Honorable Linda Marquis.
Now.
Judge, can I rebut to that, please?
No.
There's
Now.
evidence here.
You submitted to this court and filed with this court on March 13, 2018, your exhibit list. Included in that exhibit list, I'm looking at page number 7, that's your proposed exhibit number C, a letter from counselor. Dated August 31st, 2017, it's a letter to me, the Honorable Linda Marquis. It's interesting, I had some questions about that last sentence in that first paragraph. I was kind of concerned about it. Asked you about it a couple times. Counsel, I asked you about it a couple of times.
Yeah, I asked the
Turns out, and you're not going to talk right now, turns out on September 27, 2017, you filed a reply to an opposition and counter motion, and attached to that on page 18 was a letter from the counselor. That letter is dated August 31st, 2017. It's the same letter to me, and guess what's not there? That sentence in the first paragraph that says, I do not believe Mr. McDonald is a harm to his children or himself. So I guess my concerns were right. You, my friend, were attempting to defraud this court with fake evidence. Now, you are not going to talk. I'm going to appoint counsel to represent you because now your Sixth Amendment does kick in. And you will face criminal contempt charges in front of me. And I will appoint you counsel free of charge. So I'm going to see you back next week.
Judge, I did.
No. Do not talk to me about this now until you have counsel present. Wednesday, March 21st at 1 p.m. for appointment of counsel. Counsel, I'll need you there as well. Your client's appearance is waived. On that date, I will issue the order to show cause. It will come from the court. And then we will set the order to show cause date, and we'll make sure that your counsel is available on that day, and we'll look at it on our calendars and see how much time they need to prepare. Counsel, this counselor, no. I am not going to let you speak right now. You are facing criminal contempt. Anything you say will be held against you. Do you understand? I am not letting you speak. Counsel, this counselor, Nancy Sargent Hunterton, she will need to be subpoenaed for the order to show cause date. She will appear in this court and testify about that letter that she wrote to me, that she provided to Mr. McDonald. Not on the date next week, but on the show cause date. All right, counsel? Thank you so much. Good luck to everybody. Have a great day.
Judge, we're on. This will be in the movie one day.
No. Get her. Pack your stuff up. Time to go.
You're in contact, huh?
Don't talk to me.
It's been a freaking year, man.
front of me?
Good. I don't know, you can't say a year.
This was not the end for Michael Lee McDonald. In fact, just the beginning. He has now graduated from messing around in family court to messing around in criminal court. This leads to bad results. He hires a crackpot lawyer named Craig Tester. You saw him when Michael was resisting arrest. These two men will navigate the Nevada court system for the next several years. Dr. Business wishes Candace, Joe, and their family the best. If they ever come across this video, I hope they know that all of this was out of respect for them and the example they have set. Teachers really do have the biggest hearts.